Y'all managed to scare off the students.
Oh, the mortgage foreclosure probably did that.
Now, I'd like to reserve 5 minutes of my time for rebuttal.
All right, when the yellow light goes on, you'll be into your 5.
Okay. May it please the court, my name is Andrew Byrne, and I represent the appellants, Sterling Crest Limited Partnership and Roll American Development Incorporated. In February 2013, two sophisticated entities entered into a very lengthy contract for the purchase of a 360-unit apartment complex in Orlando. And 3 months after that, the contract failed. And it failed because my client, Sterling Crest, could not deliver the property for sale.
Despite the representations to the contrary.
Despite the representations to the contrary.
And the representations weren't that we will obtain the consent. It was, we have obtained the consent. We have all necessary consents.
Exactly right, Your Honor. My client believed that it had that consent, but...
And below, your argument was, well, we established a course of dealing. I realize that you're in a very difficult position because you've got general partners and limited partners, and you're representing the partnership. But one of the issues below was whether or not the course of dealing between the general and the limiteds established a reasonable belief on behalf of the general that he had the necessary consent.
Exactly right. And the general believed that. However, the limited did not. And there was a disputed issue of fact as to whether or not the limited gave consent or not. There was oral conversations on part of the general, the president of the general. There was a single email where the limited said, sounds like a good idea, but he acknowledged in his deposition that he didn't get it in writing, and he believed that the limited partnership agreement required that, and he should have. In fact, he said it was a mistake. The limited, on the other hand, said, you know what, I never gave consent. Yes, I did talk to you. Yes, I did see that you were marketing the property, but in the end, I never gave that consent. And so there was the he said, she said dispute of fact as to whether or not there was consent.
So your position, is it your position that we should reverse it and say that, I think it's clear that there's no written consent. Is it your position that it's a reversal and it becomes a triable fact, triable issue anyway, as to whether or not there was a course of dealing or there was some kind of consent given? Or is it your position that we ought to just say as a matter of law that there was, the record doesn't contain any written consent, that was required, end of story?
No, sir. My position is that we don't even get to that, really. That's one issue that is our alternative. We don't get there because on the day of the closing, the contract had two outs for the seller. One was, if a court enters an injunction to stop this sale, then we are relieved from performing. It's an interesting argument, and I understand your argument based upon the wording of the statute, of the contract provision. But it's a tough one to swallow, that essentially, I don't mean this in an evil sense, that the wrongdoer, I don't mean to suggest that the limited partners here were evildoers. I understand they had their contract rights, but that the partnership can make the representations that it made, and then because of its own representations, which turn out to be untrue, unfounded, unclear, not quite kosher, then take advantage of that by initiating litigation or parts of the partnership. It's a hard one to swallow just from a fairness standpoint. What makes it fair is that these parties negotiated that language in the contract.
Well, they also negotiated the representations.
They did, and they could have easily said, these representations are absolute, and you do not have an out. You do not, in other words, have the option to cure. if an injunction is entered preventing you from delivering the property, that's too bad, you're going to be liable under this contract. But that's not what they did. They could have easily done that, you're right. And they could have negotiated and said to themselves, we are going to say that if some third party enjoins this sale, it has to be only the purchaser, or it has to be someone other than a limited partner. They could have said that, but they didn't. And
Yeah, but to accept your argument, wouldn't that create a situation where a limited partner, you all could just agree some limited partner is going to hold back, see how the market fluctuates between the time of the contract and closing, and then step up the day before closing and, if the market's gone south, if you would, for the seller, and say, I object and I'm filing this lawsuit.
the parties could...
Wouldn't we be creating a situation which would just be ripe for abuse by a limited partnership?
I can't imagine any rational partnership that would enter into a contract and then spend a year and a half, as the facts of this case support, fighting a limited partner to close a deal and spending hundreds of thousands of
That
dollars.
may be in this situation, but to accept your argument would mean allowing the scenario I just described.
Your Honor, I would submit to you that if there was an equitable overall right to purchase, but there's nothing unfair about saying to a party, I'm going to hold you to the agreement you entered into. Next time, perhaps, a purchaser will say, you know what, I'm going to build into my contract some protection that I wish I had done this time. The facts don't support that anyway, because I can't imagine how the partnership in this case would have decided to, let's enter into a contract and then spend a year and a half and $500,000 to get out of it.
But if we view the limited partner as part of the partnership, that is part of the party that entered this agreement, then in essence, you have, by their own actions, preventing the closing from going through.
You would. However, I would say that the difference between a limited partner and a partner, to borrow from Mark Twain, is the difference between lightning and lightning bug. Because a general partner has total control over the partnership. Limiteds have nothing whatsoever. They don't even owe a fiduciary duty to other limited partners or the partnership. They very much are third parties to the transaction because they can control none of it. They're like individual shareholders. So in this case, when the lower court entered the injunction on behalf of the limited partners over the strong objection of the partnership.
Isn't that argument you're making, though, contrary to your other argument that limited partners, because this was a sale outside the ordinary course of business, that limited partners do have a right to prevent the sale from going through?
Well, the irony of it is that we didn't have the authority, and we didn't have it under the contract, and we didn't have it by statute without the consent. Now, again, I don't think it is inconsistent to say, as a general partner, we thought we had consent. But as it turns out, the court didn't believe us in front of the lower court, or at least it was a question of fact that did not allow us to get out of the contract for a year and a half of litigation. So I don't think it's inconsistent to say that. And when you have a partnership that literally is at an arm's length with...
The limited partner has just about no rights, but if this is a sale out of the ordinary course of business, you're also arguing that they have the right to kill the deal. So that's...
They did.
Some ability to affect the business of the partnership.
In that one limited respect. Now, I acknowledge that there is a little bit of a confusion in the statutes about this, because the Uniform Limited Partnership Act does contain a provision that says that the general partners all have to agree. And then it goes on to say that the limited partners do not have to agree for the sale outside the ordinary course of business. But then we have 8303, that does add that on there, in the R&R case that construes the general partnership agreement and the limited general partnership agreement as both applying to this transaction. But for that one case, I would have to concede that the limited partners would not have that legal authority.
Well, but there's in 620-1406, subsection 5, it says, a transaction described in paragraph 1I, and paragraph 1I is a sale of substantially all of the assets outside the ordinary course of business. It says, "A transaction described in paragraph 1I shall require the approval of limited partners owning a majority in interest for the consent to be effective." So, under the statute, I agree that they've kind of got it all spread out all over the place. But doesn't the statute clearly require that you have to have the consent of the general and a majority in interest, laying aside what the partnership agreement says?
Well, the way I read 1402 with 1406, and I'm going by 1406 2, which says the approval of the limited partners is required with the exception of a transaction described in paragraph 1I, which is the selling, leasing, exchanging otherwise of substantially all of the property of the partnership. But then, agreeing with Your Honor, 8301, which is the Uniform Partnership Act.
Well, but just look down to subparagraph 5. Look at the second paragraph of paragraph 5 of 1406, which I agree is stuck in the wrong place. I mean, I read the statute 12 times before I saw it.
Yep.
Transaction described in paragraph 1I also requires the approval of limited partners owning a majority of right to receive distribution. So if you stop at subparagraph 3, you would say, well, the limiteds have nothing to say about it, and then it's like they kind of, as an afterthought, stuck it someplace else.
I agree, and of course, this was not a basis on which we relied in our brief, but I agree with Your Honor that this does add to, yet again, the requirement that the limited partners have to agree to the sale. The point is that on the day of closing, the contract itself provided that the seller, in this case Sterling Crest, did not have to perform. In addition, we had the problem on top of that although we thought we had consent, we clearly did not. And because we didn't, we could not legally transfer the property.
Let's talk a little bit about the ready, willing, and able aspect of the buyer.
Yes.
And is your position, let's forget the facts of this case for just a minute and just talk about the theoretical.
Yes.
Sign an agreement on day one that says that the closing will occur 100 days later. And on day 2, the seller says, I'm not going to perform. And then defends on the basis, well, you didn't have the money on day 2 to perform. Do you agree or disagree with the idea that for purposes of determining whether or not the buyer was ready, willing, and able, had their money lined up, you would focus on would they have been ready whenever the closing came up? In other words, this contract contemplated they'd have 100 days to come up with the dough. You anticipatorily breached on day 2, so we're not going to look at, it's true they didn't have the money on day 2, but they had 98 more days to come up with the money. And can they take advantage of that and then say, well, Judge, if we had been given the opportunity, here's the evidence that shows we would have had the money?
I agree with that.
Okay.
I think you focus on the day of the closing when it would have occurred. It would be unfair to say the day we breached because, as you point out, they weren't required to close then. That's the problem we have in this case, though.
Well, let me ask, I think I know where you're going, but on day 100, would you have to show that you had a commitment from the bank? It would have been reasonable for someone on day 2 to say, there's no reason for me to go through all the bank paperwork because they've said they're not going to close on day 100.
I don't know, well, those facts didn't exist in our case. When we took discovery, that's in the record, the question was, let's focus on the day that we were to close, May 13th.
Right, but it did happen to some degree because you had a deposition from a bank official that said we most likely would have given or probably or would have given the commitment, but you had testimony that the commitment had not been given.
And the problem is that we're talking about two different situations. One is the vast majority of real estate transactions versus the extraordinary remedy of specific performance, which requires something totally different. And the case law, the Lusignan case, for example, where the gentleman comes into court and he says, I have a friend here with money in hand who says, I commit to giving you the money. And the court said, I'm sorry, but for the extraordinary remedy of specific performance, you have to show you have legal control over that money. And what was clear in this case was that all these parties that were going to come together were doing so voluntarily. The Conover people, they had no idea whether they had the money or not, or any documents to show any obligation. The Stonecutter people in New York said, we feel a reputational commitment, but they had no legal obligation. The bank itself said, yeah, we were going to do this. However, their commitment letter said quite the opposite. So at the end of the day, for purposes of a real estate closing, yes, I think that's the reality of a lot of closings. But when you move to specific performance, it's an entirely different standard. There may be other remedies that a non-breaching party has, but specific performance requires that specific control over the property, which did not exist in this case. At least there was a question of fact about that. And the lower court, I think, erred respectfully on summary judgment, deciding that there was control over the money, deciding that there was a commitment by the limited partner, and respectfully ignoring the contract language that, as a matter of law, I don't see how anyone can overcome other than to say, we're going to let you out of the agreement you wrote. I see that I'm into my rebuttal time, so I'll keep the rest of my time for rebuttal.
Okay.
Good morning, Your Honors. May it please the Court, Dorothy Easley of Easley Appellate Practice on behalf of Blue Rock Realty Group, and it's an honor to be here. I've been listening to the Court's questions, and I tried to structure the argument today around the areas where I thought the Court might have the most questions, but I think it's important to underscore why the summary judgment here on Count 2 specific performance was entirely correct. And I don't think we've really brought out on either side the fact that there are 45 paragraphs of undisputed facts in the pretrial stipulation, and that's really unusual in a civil type of case to have that many undisputed facts. And what I want to do is summarize what the facts are, but I'd like to point the Court to particular record references, which are 535 through 536, particularly paragraphs 28 through 32, 35, and 44. And they stipulated this transaction was with knowledge of all the partners. There were, quote-unquote, numerous communications between the general partner and the limited partners. There was no objection from the limited partners until almost 2 weeks post-execution of the PSA, the Purchase and Sale Agreement.
What's your position as to what the limited partners did or did not have to do with regard to this transaction?
Well, to cut right to where I think the Court's going, which is whether there was an issue of fact on the point of consent.
I'm looking at the legal question of whether or not there was a requirement of consent or whether the general partner had the authority to enter into this transaction.
There is a requirement of consent if it is outside the ordinary course of business. And as to the issue of consent, even if the Court were to conclude that there was a requirement of consent, we go to the partnership agreement, which, by the way, we were not even privy to. We were not put on notice of, but the agreement itself says consent by, quote-unquote, any act.
So you agree there's a consent requirement, and you say the undisputed facts show that whatever consent was necessary was given here?
No, Your Honor, I don't concede that there was a consent requirement. Now, I understand that the Court has referred to subsection 5 and within the statute, but this was a transaction in the ordinary course of business. An argument has been made that this was outside the ordinary course of business, but the selling of an investment property is within the ordinary course of business, and that's what the general partner, Chapman, extensively testified to, even the last 5 minutes of the deposition. So we don't concede.
Well, I noticed in your brief that you said that both Mr. Chapman and Dr.
Reich.
Had they bought and sold properties.
Yes, Your Honor.
What I think is the focus is to focus not on their outside business ventures, but on this business venture. My understanding of this business venture was it was formed for the sole purpose of building and operating the apartment complex in question. And when I look at the partnership agreement and talk about, it's to acquire the land, to obtain the financing, to construct the apartment building, to manage, operate, and rent the apartment building. I mean, the only language in there that probably or maybe gets you where you want to be is to carry on any and all business and investment activities incident to the foregoing.
That's right, Your Honor, and that's...
I guess the question then becomes, if you've got this long business practice of basically operating an apartment building, is the sale of that sole asset incident to the foregoing?
Yes, Your Honor, and let me explain why. First of all, we are relying on that language of all business investment activities incident to these activities at Record Site 105 and 1164. And the reason we're relying on that is, at the end of the day, this is investment property. And selling for an enormous profit a property that was going into foreclosure, I think we can all agree is a good investment, being able to walk away with a profit. The reason the limited partners are objecting is they didn't anticipate their tax liability and their prepayment penalty, and the longer this litigation drags on, the lower their tax liability and the lower the prepayment penalty. But there's no question, all the partners are walking away with $27 million in their pockets, so this is an investment property, like many investment properties run by limited partnerships, and this is an investment property for which the partners are going to walk away with a lot of money.
Let's come back, though, and focus on this. I mean, it seems to me that it either is in the ordinary course of business, or it's not.
That's right.
If it is in the ordinary course of business, then your position, and I think a correct one, is that the statute does not require the limited partner's consent.
That's right, Your Honor.
If it is not in the ordinary course of business, do you concede that the statute does require the consent of a majority in interest of the limiteds?
Yes, Your Honor. We would concede if it's not in the ordinary course of business, but then we go back to cases like R&R Investments and Enry 12 Oaks, or I think it's Enry 12 Oaks. Yes, the Enry 12 Oaks cases where there were partnership agreements, cases where the general partner did do something outside that which was authorized under the partnership agreement, and the courts held that the partnership was still responsible. And I think, going back to Your Honor's questions, Judge Evander, you were pointing out the fact that otherwise those who are not privy to these partnership agreements, a partnership can engage in all sorts of activity. Here we have 5 paragraphs of assurances. These weren't just representations, these were warranties of authorized activity, and they had the full authority to engage in this activity. They had the full authority to sign this purchase and sale agreement and close this deal. And when those warranties are made, and the innocent third party, and again, Blue Rock is the only innocent third party here, where they warrant that they have the authority, and the general partner engages in an activity which is customary for multi-unit apartment buildings to sell them for a profit. They're an investment property. They're selling them for a profit. What courts do is look at ordinary course of business in terms of the conduct of the partnership and what they lead the third party to believe. And here we have the conduct of the partnership leading the third party to believe, warranting to the third party to believe that this is all a customary transaction. And Scott Zucker of Stonecutter testified in his deposition, they have 12 agreements like this, more than 12 agreements like this in Florida. This is the first time we've ever had any issue with this agreement. And this isn't complicated. It's long, there are a lot of words, but it's not a complicated transaction, and it's customary for limited partnerships to sell their property. So to bring closure on answering Your Honor's question, because I can be long-winded, this was in the ordinary course of business. It was not required by statute for consent by the partners, but even assuming consent was required by the limited partners pursuant to their partnership agreement, they did consent. And I think the trial judge...
Did they consent, is it your contention that they affirmatively consented, or that they acquiesced by not objecting?
They affirmatively consented. No different from me saying, honey, I want to sell the house, and my husband saying, I think that's a great idea. And then I go and I sell the house, and I get no objection from my husband. And I use that example on purpose because although it's suggested that the partnership is divisible, by statute, the partnership is joint and several.
But you don't think implicit in that statement, honey, I want to sell the house, and your husband saying, I think that's a dandy idea, is, I think I want to sell the house on terms that are favorable to us as a seller. I mean...
That's right. And these are favorable terms.
And you know, I mean, I don't know anything. I mean, I get the impression from the, looking at the emails from Dr. Wright, that her concern was that she wasn't going to, despite the selling price, because of the recapture on the operating losses that they had taken and the depreciation, that they were going to have some adverse tax consequences, that she was actually going to have to pay money in essence, subsequent to that, to be able to close the deal. And you know, I'm not saying that's a good idea, bad idea, otherwise, but isn't that a rational thing for an investor to consider? That, you know, I can't do this deal because tax consequences, not because the price is inadequate, but because I'm going to get hammered on the taxes.
And that's absolutely, Your Honor, and as the appellant pointed out, these are two sophisticated entities. This isn't their first rodeo. They've been engaged in these types of transactions for 3 decades. And for that very reason, they have to do their due diligence too. They were represented by counsel. Both sides were represented by counsel. It was their job to do their due diligence. It was the general partner's job to do his due diligence. And to further answer the court's question, this would allow any limited partnership after the fact, when they have seller's remorse, to back out of the deal and turn partnership agreements into turmoil, and really the law of contract into turmoil.
Is it really that, or does it simply require that if there's even any question about whether or not the sale is in the ordinary course of business, that that the buyer get a copy of the partnership agreement, at least to the extent that it identifies the limited partners, and then gets their written consents as part of the contract?
Your Honor, the buyer pursuant...
How is that any different than if you and your husband own the property together? I mean, anybody that you understand, because of, even if the deed is in your name, if it's your homestead property, that you got to get your spouse's joinder on it, so they're going to have spousal joinder. I mean, the fact that people who may be a stranger to the title, like a spouse in a homestead property, they're not on the deed necessarily, but they have to join in, isn't a great mystery in real estate law.
And I think the response to that is that we're governed by statute, and pursuant to 620.1103 subsection F, and we also cite to the R&R Investments decision, third parties have no obligation, and this isn't just the rule in Florida, it's the rule nationwide. Third parties have no obligation to investigate these partnership agreements unless they are put on notice. And that's in the statute. And the reason for that is we can't do business if they have to indulge in reviewing every partnership agreement. That's why we get these warranties, these robust warranties. Otherwise, why get the warranties? They're meaningless. And to allow the partnership to back out after the deal because they didn't do their due diligence and maybe they're not getting as much money as they thought they were going to get undermines the entire rule of contract. And again, I'm citing to 620.11034F and R&R Investments and Henry 12 Oaks. Again, the partnership is bound when it's in the ordinary course. It's custom. One would reasonably expect a limited partnership engaged in managing and investing in multifamily units to sell them for a profit. And this is no small amount of money. We're talking about $27 million. And that, yes, Your Honor.
Going back to the ordinary course of business, is there anything in the contract, representations or anything else which would suggest one way or another whether this was a transaction which was in the ordinary course of the partnership's business?
Your Honor, when we go to the representations themselves, let me look at the language, because they talk about having the full authority and this agreement being a valid and enforceable agreement, a legal agreement. And reading that language, again, in section 15A through D, reading that language, that would alert anyone that this is in the ordinary course of business. Again, these weren't just representations, these were warranties that were in the agreement itself. And I think that, again, I don't want to beat a dead horse, but going back to what is an investor supposed to think? These were two sophisticated entities. This general partner has been operating in this fashion for 30 years. This general partner is known in the industry and known in the business for operating in this fashion, and this is Chapman's deposition I'm referring to. But in the article A through D, the seller has full power and authority for legal, valid, and binding obligations. And the seller, reading for paragraph C, is duly authorized and unanimously approved by the, and then skipping over to general partner and other officers of the seller. And then D, neither the execution, delivery.
If they approved by the general partners, by the limited partners, or what?
It just says general partner and officers of the seller, and again, pursuant to statute, there is no requirement for the approval by the limited partners, but even though we weren't privy to the partnership agreement, when we go to the consent provision, it's consent by words, by a writing, or by act. And again, if investors cannot anticipate and presume, just like a mortgage lender can't, why wouldn't a mortgage lender presume that a general partner in the ordinary course of business would take out a loan? And again, even if the loan is in excess of what's authorized by the partnership agreement, the partners are still responsible in this case as well. The selling...
That's true, but only if it's in the ordinary course of business.
That's right, Your Honor.
I guess that's one of the questions that, I'm kind of torn in this case, because on the one hand, I think, what more could you have done? What more could your client have
Exactly.
done?
What more could we do?
And I'm kind of torn because I think, well, what could the limited partners here do to prevent their general from going out and doing something that they weren't supposed to do?
And that's, well,
So
I'm
it
sorry.
seems to be, it comes down to, was this in the ordinary course of business, or did the course of dealing between the limited partners and the general partners establish that, I don't disagree with the idea that they can have an informal way of doing business that becomes so ingrained that it's just the way they do business, and that might impute to the general the authority to do this. My concern is that it's a summary judgment case, and that's not really fully fleshed out.
Well, Your Honor, and again, to address your concerns about how does a partnership protect itself from a general partner, Florida statute envisioned that situation, and by Florida statute, they can file the partnership agreement, they can file affidavits and certificates, they can limit the scope of the general partner's authority. They can do that and thereby put the general public on notice, third parties on notice, which is what they should have done. And notably, they haven't done it here. They didn't do it before. They haven't done it now.
Does that provision apply to limited partnerships? Because I was looking at that statute, and
The way I read it, Your Honor, I think it does apply because...
it's in the general partnership statute, and I look to see, a lot of times they'll put in a statute that says, we're borrowing provisions from some other one, and I couldn't find anything to that effect that made that applicable.
Your Honor, I defer to your reading of the law, obviously, but I do think...
Big mistake.
Well, I do think that it does apply, and again, even if we don't have a statute directly on point, it's our position it does apply, but if we don't have a statute directly on point, we certainly have the common law to support the idea that they must put a third party on notice. If the general partner is exceeding, they have to give them the partnership agreement. I'm sorry, Your Honor, you had a question?
You have an argument in your brief about the interpretation of 620.1406, and specifically 1I of that paragraph, which seems to be arguing that the general partner could do it without the limited partner's authority, even if it was not in the ordinary course of business. So
No, Your Honor, I don't think that would be a correct construction of the law. It has to be in the ordinary course of business. And so I don't want to mislead the court on that point. But the point is, as to the ordinary course of business, again, investment, property, we're selling for a profit. We're about to go into foreclosure. We're going to make a profit. It was in the ordinary course of business.
See, because the statute says the actions that require the approval of all general partners, include selling or otherwise disposing of all or substantially all of the limited partnership property, other than in the usual and regular course of business. So it says you have to have the approval of all the general partners if you're selling all the property other than in the usual course of business, and then a later paragraph says you've got to get the approval of the limited partners with the exception of a transaction described in 1I. Well, isn't the transaction described in 1I the sale of all the property other than in the usual and regular course of business?
I think I understand Your Honor's question, but I think that I'm reading that language differently, because you can sell all the partnership assets. The question is, are you selling all the partnership assets outside the ordinary course of business? And Chapman testified in his deposition that it was understood that they would ultimately sell this asset. In other words, it was never envisioned that they would hold this asset for all time. So that, again, goes back to it being in the ordinary course of business. The fact that they're selling all the assets, in other words, isn't if they were selling Hillary Reich's car, that wouldn't be in the ordinary course of business. If they were selling her house, that wouldn't be in the ordinary course of business. But to sell an investment property for a profit is in the ordinary course of business. And then in closing, the trial judge on pages 590 through 91 of the transcript recognized what was going on. This is an internal partnership dispute. It's to them. The property can close, the property can be sold, they can litigate how that money is going to be split up, but that has no bearing whatsoever on the innocent third party here.
Let me just ask one question, and
Certainly.
we're out of time, so maybe the Chief Judge will indulge me. One of the issues that you addressed in your brief but didn't address today is one of jurisdiction. I mean, I view this as in the nature of an injunction or in the nature of an order allowing immediate possession of property. I mean, is that really is that a fight that you really are making, that you don't agree on the jurisdiction?
Again, this court determines whether it has its own jurisdiction. As a practitioner, we have an obligation to raise jurisdiction, also for the purpose of saving the client's money. A case should not go through to oral argument and then the court to realize it doesn't have jurisdiction because the parties did not raise it. So I felt it was an affirmative obligation to raise it to the court.
You
I
really
saw-
want an opinion for title purposes? Would an opinion help you that says, we can't decide this case because we don't have jurisdiction? How would you ever get that title insured?
Your Honor, as you noticed, I didn't bring it up at oral argument. I think the court's already concluded that the court does have jurisdiction, and I defer to the court's wisdom on that. So we would ask that the court swiftly affirm the summary judgment rather than reverse and remand, because this is a bench trial and we'll just be kicking a can down the road. And I appreciate the court's indulgence in allowing me to be maybe a little long-winded today. Thank you.
Thank you, counsel. I want to address the point that the court has raised about the ordinary course of business. I don't have the entire record here in front of me, but if you look at tab 8 of the record, it does contain the limited partnership agreement amongst the general and limited.
Let me ask you this as a follow-up to that. Would you agree a limited partnership could be in the business of buying and selling property? And
It could be
It
anything.
could be, for some businesses, some limited partnerships, it could be in the ordinary course of business. You know, that's what they do. They go, they buy property, maybe they improve it, and then they sell it, and that's the nature of the limited partnership.
Theoretically, yes.
Yeah, so selling all or substantially all of your assets for some limited partnerships could be in the ordinary course of business.
It could be anything. That's exactly right.
Not limited partnerships, it may not be in the ordinary course of
That's right.
business. How, in this case, is the potential buyer to know whether it's in the ordinary course of business or not?
Well, I would say that in the agreement itself, the limited partnership agreement itself, it says in its purpose that the purpose of this limited partnership is to build and operate a 360-unit complex.
Right, but was
It
that
doesn't
limited
contain-
partnership agreement provided to the buyer?
No.
So that's what I'm asking. So you have, your general partner says, we have this property for sale, and a prospective buyer says, we're interested. And then, who has the burden to say whether this is in the ordinary course of business or not, or how does the buyer determine that?
Well, first of all, what the buyer could have done in this case is simply ask the question in its due diligence. It could have said, give me the affirmative consent of the limited partners, let me see your limited partnership agreement, and then I will know. The law doesn't say that it's within the knowledge of the purchaser as to whether it's in the ordinary course of business or not. It just imposes that obligation, period. So that's what they could have done. Here's what else they could have done. They wrote this contract, the purchaser did. So when the seller comes to the table, they could have said, going to Article 17, if there's an injunction issued, it has to be someone other than a limited partner. They could have said that. They could have said, for example, in Article 15, if you are incorrect, and by the way, there was a stipulation in the lower court that it was not fraud involved here, it was a negligent act. They stipulated that my client thought he had consent, but it turned out he didn't, okay? So that's a little different equitable case than my client intentionally made misrepresentations, which was not stipulated to below. Okay, so they could have done this. They could have said, under Article 15, we're not going to give you the right to decide in your sole and absolute discretion that you will not cure a misrepresentation, which is exactly what they didn't do. They said, we do have that absolute discretion. They could have said, we're going to require you to produce a copy of the due diligence of, I see that my time is up, but they didn't do any of those. So for the reasons we state in our brief, we respectfully request that the court reverse based upon the contract and enter judgment in favor of the appellants in this case.
Thank you, counsel.
Thank you.
Thank you all.
We'll have a panel change now for the last case on the docket.